Welcome to the Deep Dive, your shortcut to being well informed. Today we're plunging into a really fascinating topic, how Japan, a global tech powerhouse, is legally navigating the whole AI revolution. We often hear about the EU's approach comprehensive, sometimes pretty stringent regulations, but Japan, they charted a remarkably different course. So our mission today is to unpack the stack of sources you've shared about Japan's legal and regulatory landscape for AI. Looking ahead into 2025, we want to pull out the key insights, the surprising bits, and really what makes Japan's strategy stand out.
Absolutely. And what's fascinating here is exactly that contrast. How Japan is trying to strike this balance between fostering innovation, which they prioritize, and mitigating the risks that obviously come with AI. They're leaning heavily into what's called a soft law approach. It's quite a departure from some other major players. And this raises a big question right from the start, doesn't it? Can a flexible, framework-based system like this truly keep pace with how fast AI is evolving? Or does it maybe risk leaving too much, gray area down the line? It's this classic agility versus certainty question.
Okay, let's unpack that, this soft touch approach. Because honestly, it is surprising. You might just assume a tech leader like Japan would have, I don't know, a single big AI law already. But they don't. In fact, our sources, especially this AI Governance in Japan version 1.1 document, they make it really clear. This isn't an accident. It's an intentional choice. They seem to believe these broad regulations are, well, unnecessary right now if you want to foster innovation. So if it's not one big rule book for everything AI, what are they doing exactly?
Right. They're kind of building this regulatory mosaic. It's much more focused on guidance and sector-specific rules rather than one sweeping prescriptive law. And if we look at the bigger picture, the soft law idea shows up mainly in key documents like the AI guidelines for businesses that was updated by METI and BMIC just in March 2025. And then there's the proposed AI bill from February 2025. Now, those AI guidelines for businesses, importantly, they're non-binding, a classic example of soft law. They're grounded in these human-centric principles they laid out back in 2019, things like dignity, diversity, inclusion, sustainability. It's quite a sophisticated mix, risk-based, goal-oriented, and built on this idea of agile governance.
Agile governance. Okay.
Yeah. And these guidelines, they lay out 10 core principles. You've got human centricity, safety, fairness, privacy, security, transparency, accountability, literacy, fair competition, and innovation. It's also worth noting they align pretty closely with the G7 Hiroshima AI process. That signals Japan's commitment to playing nice globally, interoperability. And these guidelines, they get quite specific, detailing role-specific expectations for basically everyone involved, developers, providers, business users, covering things like data governance, bias mitigation, safety testing, red teaming.
Red teaming, right? Like stress testing the system.
Exactly. Simulating attacks to find vulnerabilities, plus documentation, incident response, the whole package.
Okay, so these are really detailed recommendations, guidelines, but not strict legal mandates. That's a massive difference. And then there's this AI bill you mentioned that sounds more official. Is that where the teeth are?
Yeah.
The penalties?
Well, not quite. The AI bill is significant, yes. It would be Japan's first AI-specific statute. It's a framework law, about 28 articles, sets broad principles, tells the government to create an AI basic plan. It even sets up a cabinet-level AI strategy headquarters to coordinate everything nationally. But, and here's the kicker, this is really crucial for you to understand. While it says private companies should strive for active AI adoption and cooperate with government measures, there are no penalties for not complying. None. It's just government guidance or advice.
Wow. No penalties. That is genuinely striking. So Japan is really, really banking on ethical conduct and self-regulation here. But how does that practically work? Does it just rely on industry goodwill? Or I wonder, could that create a weird competitive situation compared to places where big fines are a real threat?
Well, that's exactly the heart of that agility versus certainty dilemma we talked about. Japan's strategy is laser focused on balancing innovation promotion with risk mitigation. It all ties into their Society 5.0 vision.
Right, that human-centered society idea, integrating cyber and physical space.
Precisely. So the thinking seems to be that industry will generally comply because of reputational risk, the need for global interoperability, and just understanding that good governance is, well, good for business in the long run. It's about encouraging best practices rather than cracking down with strict rules. The hope is this flexibility allows for rapid adoption without killing off the innovation spark.
Okay, so if Japan isn't writing a whole new AI rulebook, how is it adapting the old one? It sounds a bit like trying to fit, I don't know, a spaceship into rules made for bicycles. Where does it get really interesting or maybe even a bit messy?
That's where you see this fascinating agility in action. They're often reinterpreting existing laws rather than drafting entirely new ones. Let's look at a few examples. First up, data protection. That's under their main data law, the APPI. A really key amendment back in 2022 made it significantly easier to use personal data for AI machine learning by processing it into what they call pseudonymized personal information. Basically, data where you can't identify someone unless you combine it with other info. And the big deal is this kind of data can be used for new purposes like AI training without getting prior consent for that specific new purpose. That's a huge green light for AI development in Japan.
Okay, that sounds like a major advantage for developers.
It is, but it's not a total free-for-all, especially with a generative AI. The Personal Information Protection Commission, the PPC, they put out these cautionary notes in June 2023. They basically warned that just dumping personal info into a Gen AI service without consent, if that data gets used for machine learning by the service provider, well, that could violate the APPI. Companies need to actually check that their providers aren't using input data for training. They even specifically flagged a model called DeepSeek in February 2025, pointing out it stores data, including personal info, on servers in China, subject to Chinese law. So you see, flexibility, but with specific cautions layered on top.
Got it. That's a really important distinction. Okay, what about copyright and intellectual property? AI training needs tons of data, often copyrighted stuff. Is it the same soft touch there?
It absolutely is, and it's quite distinctive globally. Japan's Copyright Act has this specific clause, Article 30 to 44. It basically permits using copyrighted works for information analysis, which includes AI training without needing the copyright holder's permission.
Wait, without permission?
Without permission, as long as the purpose isn't about, enjoying the thoughts or sentiments in the work itself, or if it doesn't unfairly harm the interests of the copyright owner. This makes AI training much, much more straightforward in Japan compared to other places wrestling with this exact issue.
Wow. That sounds incredibly helpful for AI developers, almost like an open field for data. But does that potentially leave creators vulnerable? How do they ensure interests aren't unfairly harmed?
That's the million-dollar question, isn't it? That unfairly harming phrase is the key balancing act, and ultimately it would be up to courts to interpret what that means in specific cases. But also, what about when the AI itself creates something? We've had some really impactful court decisions there. Back in May 2024, the Tokyo District Court ruled that an inventor, under their Patent Act, has to be a natural person. AI doesn't count.
Okay.
And the IP High Court confirmed that in January 2025. Same story for copyright. Works generated purely autonomously by AI, generally not considered works under the law because, well, the AI is seen as lacking genuine creative expression. However, if a human uses AI as a tool, and that human has creative intent and makes a creative contribution, then the human is the author. So human creativity is still king in the eyes of Japanese law.
That draws a very clear line. Super interesting. And speaking of courts and real-world impact, that Tabelog case you mentioned, in the antitrust world, that sounded like it offered some insights into algorithm transparency. Can you walk us through that one?
Yeah, the Tabelog case is a perfect example of applying existing laws to these new AI-driven situations. Tabelog is a big restaurant rating site. Initially, back in June 2022, a lower court found them liable for abuse of a superior bargaining position. Why? Because they changed their algorithm, and that change hurt some restaurants using their platform.
Okay, sounds straightforward enough.
But wait, there's the twist. The Tokyo High Court, in January 2024, overturned part of that. They agreed Tabelog might have a superior bargaining position, but they ruled they were not liable for abuse. The key finding was that the purpose and manner of the algorithm change were, in their view, reasonable.
So it wasn't just that the algorithm changed, but why and how it changed that mattered.
Exactly. That's what makes this case so influential, even though it's still on final appeal to the Supreme Court. It really zeroes in on the reason behind algorithmic changes. It highlights issues like information asymmetry. Does the platform know something the user doesn't? And the whole principle of transparency in AI governance. And interestingly, the algorithm itself was actually disclosed during the lawsuit, even though Tabelog initially resisted, calling it confidential. That was a big deal, pushing for more openness in these black box systems. It shows courts are finding ways to scrutinize these things, even without AI-specific laws.
That's a powerful signal for accountability. Okay, now, the really big question for probably a lot of our listeners, liability. If an AI system messes up and causes harm in Japan, who pays? You said there's no AI-specific liability law, so how does that work?
Right. When AI causes harm, they fall back on the general laws. civil law like torts, contracts, product liability, and also potentially criminal laws. But there's a specific challenge with the Product Liability Act. Manufacturers are liable for defective products. Now, standalone AI software, maybe not legally a product on its own, but if it's integrated into a device like AI in a car or a medical scanner, then the whole thing is considered a product.
Okay, so integrated AI is covered.
Yeah, potentially. But then you hit another hurdle. Proving a defect and establishing what counts as adequate safety for an AI system, especially for complex AI that isn't fully explainable, that's really, really tough. There are actually official contract guidelines on utilization of AI and data, version 1.1, that explicitly call this out. They highlight how hard it is to pin down liability in these complex AI supply chains because of opaque training data and complicated causal links. So what do these guidelines suggest? They stress how desirable it is to clearly spell out responsibility in contracts between the different parties involved, which basically means a lot of the risk management right now is happening through contracts, not just legislation.
I see. So while the overall legal framework is soft, the practical challenges, like liability, are very real, and contracts are becoming super important to fill those gaps. Okay, let's shift gears slightly. Moving beyond these broad legal categories, what does this all mean for specific sectors? And for the government itself, how is AI interacting with existing rules in, say, healthcare or employment?
Good question. Let's take healthcare. AI-based software, like for analyzing medical images, can actually be classified as a medical device under Japan's PMDA, their main drug and device law. That means it needs formal approval before it can be manufactured or sold. But critically, even approved AI tools are generally seen as assisting the physician. The doctor still holds the ultimate responsibility for the diagnosis or treatment decision.
So AI is a tool, not the decision maker.
Exactly. And there's another interesting development. The revised Next Generation Medical Infrastructure Act from April 2024. It introduced pseudonymized medical information specifically for R&D. This allows detailed clinical data, just without direct identifiers, to be used for research much more easily. Patients have an opt-out, but otherwise consent isn't needed for each specific research use. This is expected to really speed up medical AI research.
That's significant. What about employment, using AI for hiring or even firing?
Well, there aren't any specific laws saying you can't use AI for hiring or termination. Employers in Japan generally have quite a bit of freedom there. However, they still have to collect information lawfully, usually directly from the job seeker or with their consent. And there are strict rules against collecting special care information, things like race, creed, medical history, or other prohibited info like union membership or even birthplace details. Now, if an AI system makes a clearly biased or just plain wrong decision in hiring or firing, that could definitely impact the legality of the decision, potentially even making it a tort, a civil wrong.
Okay, so the output still has to be legally sound.
Right. And for monitoring employees, like using AI to check emails, that's generally permissible, but only if it's clearly laid out in company rules or if there's a very clear business need and the methods used are reasonable. Transparency again.
Makes sense. And what about the government itself using AI and national security concerns?
Japan's government is definitely using AI, but cautiously. There's an agreement from September 2023 about using generative AI in government work. It specifically prohibits handling sensitive information through standard terms of service-based cloud services.
So no feeding secret documents into a public chatbot.
Pretty much. And remember that DeepSeek alert about data going to China? Government agencies got that same warning in February 2025. Shows they're being careful about data sovereignty. From a broader national security angle, Japan definitely sees AI, especially generative AI, as a critical technology. Their Economic Security Act from May 2022 designated the cloud program, basically, access to cloud computing resources, as critical material. They're planning to build up domestic computing power to ensure they have a stable, secure supply for AI development.
So the government is walking a tightrope, embracing AI, but also managing the risks, especially around sensitive data and critical infrastructure. Okay, last area then. General governance and compliance strategies. How did these guidelines tackle those big cross-cutting issues like algorithmic bias or transparency?
Right.
For algorithmic bias, again, no specific laws targeting it directly. Instead, those AI guidelines for businesses offer recommendations. They suggest developers should use representative data sets, providers should regularly check inputs and outputs for bias, and the businesses actually using the AI need to ensure their inputs are fair and they make responsible final decisions. They also advise using explainable AI, XAI, especially for more complex algorithms where it's hard to see how a decision was reached.
And transparency.
Similar story.
No specific transparency laws for AI, but the guidelines establish transparency and accountability as core principles. They say companies should provide appropriate information about their AI systems to stakeholders. But there isn't really clear guidance yet on when you need to disclose or what exactly you need to disclose. Especially in situations where AI is replacing a human service, like a customer service chatbot, that's still a bit of a gray area, an area where this soft law approach feels less well-defined.
So still evolving. Definitely. But it's really important to stress this, even though these guidelines are technically non-binding, because they're widely adopted and represent industry best practice, courts could absolutely consider them when deciding if a company breached its duty of care, for example. So ignoring them isn't really an option from a risk management perspective. They effectively shape the expected standard of behavior, even if they don't carry direct penalties. They're crucial for understanding the practical landscape.
Okay, wow. We have covered a lot of ground in this deep dive into Japan's AI legal world. We've seen this really unique balancing act between pushing innovation and managing risks. This distinctive soft law approach, relying heavily on guidelines and adapting existing laws rather than writing one big AI rulebook. The lack of penalties in the proposed AI bill to those specific court rulings on AI inventors and how they're carefully applying data protection and copyright, Japan is definitely carving its own path. So what does this all mean for you listening? Understanding these nuances is just crucial if you're engaging with AI, especially internationally, where all these different philosophies are clashing and evolving in real time.
Precisely. And it leaves us with a really interesting thought, doesn't it? Given Japan's clear innovation-first stance, this reliance on soft law, on sector-specific guidance rather than broad prescriptive legislation, you have to wonder, in a field moving as fast as AI, is this flexible, adaptive framework actually more effective, more future-proof in the long run than a more rigid, comprehensive approach like the EU's? Or does it just end up kicking the hard questions about real accountability and enforcement down the road, maybe leaving them mostly to contracts and court interpretations? It really comes back to that core tension, agility versus certainty, and how Japan's answer to that question will ultimately shape not just its own AI future, but potentially influence the global conversation too. It's definitely something to keep watching.